whether other women may have been subjected to workplace harassment, and whether such evidence has allegedly been suppressed, does not change the fact that plaintiff has failed to demonstrate that she has a case worthy of submitting to a jury. Now, Ms. Jones appealed Judge Wright's decision to the Eighth Circuit, heard arguments on October 20th, 1998, and on November 13th, 1998, before a decision was rendered, Ms. Jones and the President settled the case. Briefly then to what was happening on the front of the independent counsel's office. In mid-January 1998, Linda Tripp had brought to the independent counsel information that she had been gathering surreptitiously for months about Ms. Lewinsky's relationship with the President and her involvement in the Jones case, and thus began the penultimate chapter. As you will see, Ms. Tripp's relationship with Ms. Lewinsky and her role in these matters is more than merely a backdrop to the succeeding events. Independent counsel met with Ms. Tripp, informally granted her immunity from federal prosecution, promised to assist her in securing immunity from state prosecution, where she had been illegally taping the telephone calls with Ms. Lewinsky. On January 13th, Ms. Tripp agreed to tape a conversation with Ms. Lewinsky under FBI auspices. And on January 15th, armed with that tape, the independent counsel first contacted the Department of Justice to seek permission from the Attorney General to expand its jurisdiction to cover the investigation it had already begun. On January 16th, that permission was granted by the Special Division of the Court of Appeals. Now, the President's deposition was scheduled to take place the very next day, Saturday, January 17th. On the 16th, Ms. Tripp invited Ms. Lewinsky to have lunch with her in the Pentagon City Mall, and there she was greeted by a corps of FBI agents and independent counsel lawyers and taken to a whole hotel room where she spent the next several hours. Ms. Tripp was in the room next door for much of that time. When she left that evening, she went home to meet with the Jones lawyers, with whom we know she has been in contact for many months, in order to brief them about her knowledge of the relationship between Ms. Lewinsky and the President, so that they in turn could question the President the next morning. As the independent counsel himself has acknowledged, Ms. Tripp was able to play this oddly multifaceted role because, although as part of her immunity agreement, the OIC could have prevented her from talking about Ms. Lewinsky, they inexplicably chose not to. The existence of the OIC investigation was made public in the January 21st edition of the Washington Post and was the all-consuming focus of media coverage for the ensuing 8 months. On August 17th, the President's deposition was taken by the independent counsel for use by the grand jury. And on September 9th, there was delivered to the House of Representatives a referral from independent counsel Starr containing what purported to be information concerning acts, quote, that may constitute grounds for impeachment. The referral was accompanied by some 19 boxes of documents, grand jury transcripts, and a videotape of the President's grand jury testimony. The referral was made public by the House on September 11th. On September 21st, additional materials were released along with the President's grand jury videotape, which was then played virtually nonstop on every television station in the country during that day. The committee held a total of 4 days of hearings, one for preliminary presentations by majority and minority counsel, one for testimony by independent counsel Starr, and two in which the President was permitted to call witnesses and present his defense. In addition, the Constitutional Subcommittee held one hearing on the standards for impeachment, and the committee convened in its oversight capacity to hear witnesses on the meaning of perjury. The committee called no fact witnesses. Despite numerous efforts to extract from the committee some description of the specific charges against which the President would have to defend himself, it was not until approximately 4:30 on December 9th as I was completing my testimony before the committee, that any such notice was provided. And then it came in the form of 4 draft articles of impeachment. 3 days later, the committee reported out those articles, and on December 9th, the House completed its action, preferring to the Senate Article 1, charging perjury in the grand jury, defeating Article 2, which alleged perjury in the Jones deposition, exhibiting Article 3, which charged obstruction of justice, and defeating Article 4, which alleged false statements to the House of Representatives. And so we are here. But before moving on, let me pause on an important procedural point. Although the Senate has asked that the parties address the issue of witnesses only after these presentations have been completed, the managers spent much of their time last week explaining to you why, if only witnesses could be called, you would be able to resolve all of the supposed conflicts in the evidence. Tell me then, how is it that the managers can be so certain of the strength of their case? They didn't hear any of these witnesses. The only witness they called, the independent counsel himself, acknowledged that he had not even met any of the witnesses who testified before the grand jury. Yet they appear before you to tell you that they are convinced of the president's guilt and that they are prepared to demand his removal from office. Well, the managers would have you believe that the Judiciary Committee and the House were really nothing more than grand jurors, serving as some routine screening device to sort out impeachment chaff from impeachment wheat. Thus, as they would have it, there was no need for anything more than a review of the cold record prepared by the independent counsel. No need for them to make judgments about credibility or conflicts. Indeed, they offered you a short lesson in grand jury practice, telling you that U.S. attorneys do this thing all the time, that calling real live witnesses before a grand jury is the exception to the rule. Well, it's been a few years since I served as U.S. Attorney for the District of Columbia, so there may have been a change in the way prosecutors go about their business, but I don't think so. And so what lesson can be learned from the process followed by the House? I suggest that what you have before you is not the product of the Judiciary Committee's well-considered, judicious assessment of their constitutional role. No, what you have before you is the product of nothing more than a rush to judgment. And so how should you respond to the manager's belated plea that more is needed to do justice? You should reject it. You have before you all that you need to reach this conclusion. There was no basis for the House to impeach, and there is now and never will be any basis for the Senate to convict. Now, the managers have not shown and could not on this record or any record prove that the President committed any of the offenses charged in the articles. But even if they could, these offenses would not warrant your deciding to remove the President from office. In this regard, an impeachment trial is unlike any other. You are the judges of the law and the facts and the appropriate sanction. Before casting a vote of guilty or not guilty, you must decide not only whether the President committed the acts with which he is charged, but whether those acts so seriously undermine the integrity of our governmental structure that he must be removed from office. I want to deal here for just a moment with an argument that was advanced in the press by one of the managers, and that is that the question whether the offenses described in the articles are impeachable is not really before you, that it has already been decided by the House. As the manager put it in a press interview, quote, "Are these impeachable offenses, which I think has already been resolved by the House. I think constitutionally that's our job to do. Now, I trust in light of last week's extended discussion that the managers no longer press that notion, for it was remarkable in at least three respects. First, it's entirely inconsistent with don't worry about it, this is just a routine procedural process, leave the difficult decisions to the Senate argument so frequently heard during the proceedings in the House. Second, it's an argument that rings hollow coming from those who did not even debate the constitutional standards or seek any consensus on what those standards should be. And third, and most importantly, it arrogates to the House the critical constitutional judgment, which is yours alone. Far be it from me, or indeed anyone else, to instruct this body on its constitutional role. But I do think that it would help us all to be reminded of the words of Alexander Hamilton in Federalist number 65, because impeachment necessarily deals with injuries done immediately to society. Alexander Hamilton wrote, "The prosecution of them for this reason will seldom fail to agitate the passions of the whole community and to divide it into parties more or less friendly or inimical to the accused. In many cases, it will connect itself with pre-existing factions and will enlist all their animosities, partialities, influence, and interest on one side or on the other. And in such cases, there will always be the greatest danger that the decision will be regulated more by the comparative strength of parties than by the real demonstrations of innocence or guilt. The delicacy and magnitude of a trust which so deeply concerns the political regulation and existence of every man engaged in the administration of public affairs speak for themselves. The difficulty of placing it rightly in a government resting entirely on the basis of periodical elections will as readily be perceived when it is considered that the most conspicuous characters in it will, from that circumstance, be too often the leaders or the tools of the most cunning or the most numerous faction, and on this account can hardly be expected to possess the requisite neutrality towards those whose conduct may be the subject of scrutiny. And then, the convention, it appears, thought the Senate the most fit depositary of this important trust. Now, the President may be removed from office only upon impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. The offenses charged here, even if supported by the evidence, do not meet that lofty standard. A standard that the framers intentionally set at this extraordinarily high level to ensure that only the most serious offenses, and in particular those that subverted our system of government, would justify overturning a popular election. Impeachment is not a remedy for private wrongs. It's a method of removing someone whose continued presence in office would cause grave danger to the nation. Listen to the words of 10 Republican members of the 1974 Judiciary Committee, one of whom now sits in this body. After President Nixon's resignation, in an effort to articulate a measured and a careful assessment of the issues they had confronted, they reviewed the historical origins of the impeachment clause and wrote, "It is our judgment, based upon this constitutional history, that the framers of the United States Constitution intended that the President should be removable by the legislative branch only for serious misconduct, dangerous to the system of government established by the Constitution. Absent the element of danger to the state, we believe the delegates to the Federal Convention of 1787, in providing that the President should serve for a fixed elective term rather than during good behavior or popularity, struck the balance in favor of stability in the executive branch.